Now, what is the relating back? Relating back has two dimensions. The event has taken place. So ultimately, subsequent events will not affect, it will not efface the wrong which you have committed, the political wrong which you have committed, which disqualifies you. It's over. But if you enter into an office of profit, you're disqualified. If you resign 3 months later from that office of profit, it is not saved. You're disqualified on that date. So, Malad, that disqualification is based on a set of events. But please consider the consequences, which will be contrary to the terms of the Constitution, which says no act of the House shall be declared invalid merely because a member participated who was not entitled to. Now, first of all, here you are entitled to participate, but even if a wrong person comes in, you cannot go annulling the work being done. Today, Malad, when the defection petitions are decided, if some of them are allowed, in between laws have been made, resolutions have been passed by the House, all of them can't be revisited. So, Malad, that's the respectful answer to the ex post facto point. That as a matter of law, and Malad, I read, since your lordships have kept this question back.
What were you saying, Mr. Sauri, as a matter of law?
As a matter of law, Malad, I read the Nabam Rabia judgment not as laying down an absence of power, but as laying down a code of conduct. Let me explain what I mean, Malad. The speaker is...
On the ex post, Mr. Salve, in a sentence, can you just summarize your ex post facto on ex post facto? What is your... So we'll just, if you formulate it, we can take it down then, you know.
My formulation of ex post facto is as follows, Malad. The disqualification will have to be decided on the basis of the acts and omissions of the allegedly delinquent member on that date. But subsequent events will not cure that. If on that date you defied a party whip which was lawfully issued, that's the end of the matter. The fact that the party collapsed thereafter is neither here nor there. If it is pursued to its logical end, that wrong has been committed. And I give Malad the example of somebody who takes an office of profit. Let's get into non-controversial.
Can just continue to sort of complete the formulation. I got that the disqualification will have to be decided on the basis of the acts and of omissions of the allegedly delinquent member on that date.
When he committed those acts.
Will not cure that.
Will not efface.
The call also said.
Will not efface.
So what is the sequitur?
Yes.
What is the sequitur?
The sequitur is, however, until the date of decision.
Yes.
The person is entitled to participate. And Article 189 sub-article 2 makes it clear that his acts, his functioning in the House in the interregnum does not vitiate any actions of the House. If this is so, Malad, we have no problem in reconciling to the fact that people with the most serious allegations of having been elected by wrongful means such as booth capturing, threatening witnesses, or rampant corruption in election also continue in office. That's one of the banes of our system till such time as a election tribunal declares them to be wrongly disqualified. That's the way it is. So, Malad, my respectful submission is that yes, the rule should be amended, decision making should be made time bound, judicial review will be available where a speaker is holding back. All those are ways which we can fix this. But Malad, the legal consequence of the pendency of these proceedings and its ultimate decision, this is the principle of ex post facto which must apply. No less but no more.
Anything else, Mr. Salve? We got the ex post facto.
Third point which I wanted to make, Malad, is since the point is still in play, the Nabam Rabia judgment, and I had, Malad, given a note earlier, I believe Mr. Trivedi had handed it over, Mr. Jethmalani had handed it over.
Last time you read also, when you appeared.
Yes, Malad. No, after that I gave a note, Malad. I read the judgment as more not the absence of power, but the manner of its exercise. So it is by filing a disqualification or rather a removal of speaker, because all those provisions are shown to your lordship saying the speaker doesn't, as a matter of law, is not put in suspension. They are right. So there is no absence of power. I was not only saying.
It's about the manner of exercise rather than the absence of power.
Correct. Because my lord, abuse of constitutional power is a head which we now recognize for judicial review. Is my lord the Chief Justice saying something to me, my lord? I can't hear.
You don't read Nabam Rebia as an absolute principle that the speaker is disabled from exercising his jurisdiction when there is a motion for his removal pending.
No.
It's a caution to the speaker, and ultimately it's for the speaker to take a call whether there's a frontal assault on his continuance, whether he would like to go ahead with the hearing of the disqualification petition.
And as I read that judgment, my lord, your lordships have not said that the speaker ceases to have power, but the
what you're telling us would be either to sort of restrict it a little bit or put a gloss on the judgment. I mean, if you really read those,
my lord, we always judgments are not statutes, and we always, my lord, learn to understand them. Sometimes when things are written, my lord, those facts were very stark, so maybe the language used was a little strong. But I read that judgment as, because please see, my lord, the analysis, and your lordship has read the judgment, I'm not going to waste your time reading it. The facts were so stark. What really your lordship was doing is that the speaker had no business to do this. The actions of the speaker in that case, my lord, were open and shut case of abuse of power, is the finding. So I don't, my lord, read that judgment as absence of power. Your lordship never said that he ceases to have. There are 50 other things the speaker does, my lord. He runs the whole administrative office of the legislature. Surely he is doing all that. It's only in one area that the speaker should not act. If there is, my lord, pending consideration of all these rumpus, if there was any other resolution, of course he would preside and run the house. So, my lord, once your lordships read that judgment that way, that what really the court was trying to say is, not an absence of power, but the actions of a speaker will be tested. A speaker should be put to caution when there is a notice for his removal. His actions will be tested on well-known principles of abuse of power. Then, my lord, the concern which your lordship have would go away with that judgment being read as absence of power. And finally, my lord, if I may just hark back a little to my first opening point, apart from this understanding of the Nabam Rabia judgment, my lord, nothing else really survives. There is a note which I believe is placed at note J. My lord, I believe, I'm sorry, my friend informs me, my earlier note saying what I have just formulated for your lordship's consideration is in note F, and there is yet another note, note J. Yes, this is only to show the hazards of the but-for test. I was just told, my lord, it is marked as note J.
It's written submissions, it doesn't say note J.
It says brief note on arithmetic for hypothetical trust vote.
What's that?
Mathematics.
Yes, it's just the math. Only, my lord, this is only to indicate to your lordships that this but-for test is extremely hazardous. To guess what would have happened on that fateful day had a trust vote taken place is inviting rank speculation.
I got
Yeah.
Harish Sarve's name.
F is the earlier one on the Constitution bench judgment, the Nabam Rabia judgment.
दोपहर को कर दे दोपहर को हाँ कर दे
हाँ.
प्लीज
And this note J, my lord, only sets out, I'll quickly tell your lordship what we have basically said.
Notes तो तेरा
नहीं है वो अलग है
I have given, my lord, different places where in the writ petitions they have mentioned.
You sent it on my mail, personal mail, na?
Basically, my lord, this gives you at one place. Please, it's not there, it's no big deal. Your lordship knows it is there. Basically, what we are trying to say is, we have given your lordship the para numbers and the page numbers.
तो डाउनलोड कर देना बाद में उसको
Thank you.
If your lordship sees the from paragraph 3, on 23rd June, only 16 disqualification petitions were filed. Let's be very clear, Malad, of a few dates. On 25th June, Speaker issues notice to 16. The order of your lordships on 27th June was limited to 16. The suggestion that, my lord, there was 39 or 40 disqualifications. In fact, my lord, look at 4C. There are 2 of them who are independents. They may vote one way or the other. Their party, so their party to decide whether they consider it a breach. No prayer in any of the petitions that 39 or 40 should not be allowed to vote. So, my lord, these figures which are being given, and I have given your lordship the shifting stands in different places. And I, my lord, again underscore the point. This was only
Mr. Salve, Mr. Sibal, Mr.
To
Kaul,
finish,
Mr.
Malad,
all of you.
this-
What you were thinking was that Mr. Salve, roughly,
I'm done in 5 minutes.
That's all right. But it won't finish now.
yeah.
Can't finish. There's no point for
Mr.
that.
Salve, you will take about
5-7 minutes.
5
I'll be done by lunch.
5-7
Yes,
minutes.
100%.
Mr. Jethmalani, we are not at all rushing any one of you because these are important matters of moment. We are not just forget the facts, but we are thinking of a matter of a moment. So, how much would you take in terms
Ordinary circumstances about half an hour, but I could curtail it to 20 minutes, 25 minutes.
of half an hour? Then, Mr. Maninder Singh, half an hour, all right. Mr. Solicitor,
Are few more minutes, Madam.
so you will between the 3 of you will take 2 hours.
Realistically speaking, it may not be over.
All right, Mr. Kaul, one more thing. I thought we curbed you unduly, and then you were gracious enough to follow our edict. But the idea was to finish today, but we may not be able to wrap up today.
Yes, yes,
It doesn't
no
appear that we'll be able to wrap it up today. In which case,
Then
Mr.
let's
Kaul,
have
are
it
you-
on Tuesday then, Malad.
Mr. Kaul, one more thing. Is your conscience clear that you are satisfied that you've argued fully? Is there something which you would have still liked to, because as a judge who's seen so many seasons,
Never give
I
that
don't want you to
opportunity
leave.
to a lawyer, Malad.
You don't want to give the impression that you're not.
Actually, I would have liked to take your lordship through some of the judgments if I could, which I rectify, but what do I say, my lords, to this? I can't. I leave it to your lordships. I can't say.
All right. What we will do is this: we will hear Mr. Salve now and just wrap it up, or we can. क्या करें हम?
Well, let's wrap it up and then have it on Tuesday, Malad, after reopening.
Tuesday,
That's the only way, Malad.
on the reopening.
Then do is that on Tuesday,
On reopening.
after we reopen, the 3 of you who have to now argue, and honestly, if there's something you want to still show us in the morning after Mr. Salve has wrapped up, we'll give you a little time so that you don't feel that
Well,
And anyway, there's no prejudice to Mr. Sibal because you still have to rejoin. So
Yes, yes, now, Malad, I'll sort of rejoin without the
would it be-
haste.
Would it be all right to assess that on Tuesday, in the first session, the 3 of you will be able to finish?
Yes. Yes.
Right? Maybe so if you take.
But are we not continuing this afternoon also?
No need,
Because they're
Malad.
now going, spilling over beyond the.
Oh, yes.
where there's no
Then we
point.
get some more time also if it was.
Then what we can do is we can keep it on Tuesday. Mrs.
Yeah.
Salve, we'll hear you for 5 minutes on Tuesday.
Yes, yes.
You may want to just.
Very well.
And then Mr. Kaul, if you still want to make a few submissions on your judgment, no problem. We'll hear you on that because let's not go.
They're very kind of your lordships, very kind.
Then Mr. Jethmalani and Mr. Maninder
not
Singh,
repeat
and then
anything.
we'll hear the governor, Mr.
After, my lord,
Tushar Mehta.
I'll
And equally, Mr. Sibal, we'll give you a full.
That's right, Malad, because there's lots of things that have been said, Malad, which.
Mr. Sarode, what is that you wanted to say now? And don't mention anything, huh? We're not, it's not
No,
mentioning time.
no, Milord. Milord, I am intervener on behalf of the voters. I may be given some time to, Milord, narrate the,
Mr. Sarode, if you allow interveners and then.
whenever possible, Milord.
There'll be interveners on this side, interveners on that side.
no
Give us a
problem.
small note of a page or so. We'll look at your note, no difficulty. Just-
No, Milord, I'm supporting, Mr. Sibbal, sir, and the party, Milord. But Milord, voter side is very important as allowed by the honorable
Mr.
court.
Sarode, Mr. Sibal will be Mr. Sibal and Dr. Singhvi will be very happy with your support, but I'm not sure they want you to support them in the courts. You can have a word with Mr. Sibal. If you have some specific point, which they have not covered, then you can
Yes.
certainly have a chat with Mr. Sibal and give that point to him, and I'm sure he'll place it before us.
Yes, my lord, I will do that.
Very well then, my lord. Tuesday, I'll take 10 minutes.
Which Brother Narasimha has also, we have both been discussing this also earlier. Justice Nariman's judgment on whether there should be a time limit on the speaker to decide
Yes, Madam.
what referred.
I was going to cite that, Madam.
If we can note, yeah.
Address on that as well.
And maybe we can
I'll
have some
assist your
thoughts
lordship on that, my lord, on
on
Tuesday
some
for 10
thoughts on
minutes.
that so that we
Note the
can.
reference order is you can note.
And then-
2016 SCC online 1875.
Sampath. So that's Sampath, Madam. That's Sampath, not this. This is something different.
Megachandra's separate.
This is,
Megachandra's reference.
the other one, the other issue is, Madam, where 90 days have been fixed by Justice Nariman for the speaker to decide.
Correct, correct.
That's not that 2016.
It's what this is the, I just got it from my
That's right.
law clerk. That must be a separate reference.
That's right.
Is considered in that judgment.
Please work on it.
Yes.
Lordship, please.
Tuesday.
Tuesday.
Very grateful.
Obliged, Madam.
Deeply obliged.